Oh, thank you. Thank you, Nada. Aha, minye Misty Slater Iganyaki. My name is Misty Slater. I am a proud member of the Iowa tribe of Kansas and Nebraska. And it's great to be with you all today. I see a lot of familiar faces, thanks to my previous role, and it's great to be here. I do have Bear Moon Consulting, and through Bear Moon Consulting, I get to work with non-Native allies to better work in Indian country, specifically on policy, governance, and philanthropic endeavors as well. And I am so pleased to get to bring Adam Krappel here to speak with you all today. I had the most incredible experience to get to work with Adam on an Indigenous to Indigenous trade mission in Australia. And he was able to present some of this content to our Australian Indigenous counterparts. And it was just so impactful for me to hear this that I really thought that my American Heart Association and Voices for Healthy Kids friends and colleagues might love to hear this content as well. And Adam is, you can see, a professor at Loyola University in Chicago, and he is just a really talented speaker and lawyer. And I've also been blessed to get to work with him in another kind of a facet of my life, which is as chief of staff for the Iowa tribe of Kansas and Nebraska, working with some of his law students that he mentors on some tribal law issues. So Adam's going to talk a lot about Indian law. And you can see pre-contact to today. And I want to provide just a little bit of framing on this issue. So while you might be hearing information on laws and treaties that are quite literally centuries old, and sometimes decades, and sometimes not that old, this is the foundation for the Native experience today. So the laws and the treaties that are centuries old impacts Native Americans' lives on a daily basis in ways that we don't always even know or understand. And sometimes we know intimately how much they impact Native people. So if you wanted to work on advocacy campaigns or policy campaigns, or just build better partnerships with tribes, Native organizations, or Native people, understanding the lived experience of themselves and the previous generations and their ancestors is really important in being able to create that trustworthy relationship and a really good, strong partnership. So you don't accidentally wade into waters or need to ask them too many questions on policy. This is a very complicated legal landscape, and Adam is going to be able to kind of just give you literally the primer, the 101 that I hope you'll find really helpful, and I hope we'll get lots of good questions and feedback. But yeah, feel free to put questions in the chat box, and we'll probably have a lot of room for questions at the end. So Adam, please go ahead and take it away.
Well, thank you very much for that kind introduction, Misty. It's an honor to be presenting. As Misty noted, Indian law is really complicated and funky, so unfortunately we're going to have to do some background to try to make some sense out of what's going on in the present day. And so with that, let's see, will it scroll? Uh-oh. There we go. Okay, woohoo. All right. Yeah, so the outline, we're going to start basically prior to European contact, and we'll work our way up to the present day self-determination era. And then from there, we'll talk about one of my favorite cases, Oliphant v. Suquamish tribe. It's a good time. Anyway, before we dive into all that stuff, here's a few general principles I'd like you to keep in mind throughout the presentation. The first is tribes are nations. They're not social clubs, they're not heritage groups, they're not 501c3s, they're sovereign governments. They have police, courts, schools, and everything else a government would have. And they're sovereigns, and that's how they were prior to European contact, and that's the status they retain. Because of that, Indians are not just members of their tribes, they're citizens. That's a political affiliation rather than a raw racial heritage. And this is very important. If anybody followed the Brackeen v. Holland case last year, that's essentially what the case was about. Because if you single out Indians based upon their political affiliation with a sovereign tribe, that's a political classification, and that's constitutional. On the other hand, if you single out Indians based upon their racial status, that would violate the Constitution's Equal Protection Clause. So Indian law hinges on the classification of Indians as citizens of their tribe. And I guess a note on terminology too. Some people say Native American, some people say indigenous. Unfortunately, it's one of those things, nobody has a right answer. I guess it depends on the preference of whoever you're speaking with. But as far as federal Indian law is concerned, Indian is the legal term used. It's Title 25 of the U.S. Code is literally Indians. And as we'll see later on, it's a big factor in a lot of cases whether or not a person is, quote, an Indian. And lots of tribes also have Indian in their name. Porch Band of Creek Indian, Southern Ute Indian tribe, just to name a few. Then moving on to the Constitution itself, tribes are extra constitutional solids. They existed prior to the United States government's founding, and they've never signed on the Constitution. Therefore, Indian tribes are not bound by the U.S. Constitution because they're separate sovereigns. And when the Constitution was ratified, as we'll see in a little bit, one of the purposes was to centralize authority over Indian affairs in the federal government. And to this day, the federal government has authority over Indian policy. A corollary of that is states have no authority on tribal land. But as we'll see, that principle has been muddled over time and has caused lots of confusion. So with that, let's get rolling into the pre-contact stuff. And it's important to keep this in mind because the stereotype is often that prior to European arrival, Indians are just running around chasing buffaloes and picking berries. And, that's life in America prior to 1492. But it was actually a lot more complicated than that. So just for example, North America is a big place. There's tremendous diversity of climates. And naturally, the indigenous people that lived in different climates developed different cultures based upon their natural environments. So if you live in a place that's really cold weather, you probably develop houses to withstand the cold. Likewise, you do that wherever your environment is. As a result, there's a tremendous language or diversity of language and cultures among the indigenous tribes of North America. And again, contrary to the nomadic myth, most tribes actually lived in permanent villages or semi-permanent towns. Permanent's pretty straightforward. You're in one place all year round. Semi-permanent, that basically means you move around based upon seasonal events. So let's say some type of plant is flowering, then you migrate where that's going to be. Or if like ducks are flying over at a certain time, you move based upon climatic events to take advantage of them. And that's not just an aimless wandering. That's a strategic choice. And this still goes on in the present day US. For example, I went to University of Arizona. I moved there in July. Nobody's in town. Come December, the population more than doubles because we got all these New Englanders coming to town to escape the cold weather. Are they wandering nomads? It's kind of the same thing tribes were doing. It's taking advantage of natural environment. And again, contrary to being just nomads, most tribes were agricultural, is what genetic evidence tends to show right now. The Three Sisters crops are a big example, corns, beans, and squash. Many tribes' creation stories actually emphasize the importance of agriculture. So, and it wasn't just picking random berries, it was pretty sophisticated. So tribes would genetically modify crops. So for example, that's how corn came about. Indians bred wild grasses until we got the present day corn. And tribes would also select seeds, and they would do it by looking at the size, shape, color, and texture, and try to predict what kind of plant it was going to produce. And doing this enabled them to get genetic diversity. So for example, if you have blue corn and yellow corn, this is me making it up, knowing nothing about farming, which Misty will attest to. But if it rains a lot, the blue corn might do well, but the yellow corn might not. So when you get diversity of crop species, then you're more likely to survive in case of environmental shock. So it's a strategic move. And because tribes were effective farmers, they had surpluses of things to trade. So tribes engaged in long distance commerce. We know that. For example, tribes in the southeastern US produce some quinoa, and it's been found all the way up in Ontario. Tribes in the Pacific Northwest, they had sustained fisheries, and they would trade that all the way to the Great Plains. So there were robust economies because tribes had effective agriculture. And the commerce often facilitated military alliances and other cultural exchange too. It wasn't necessarily just a raw free market exchange, though sometimes that occurred. And to facilitate this commerce and interactions amongst people, there have to be laws and justice systems. And we know tribes had rules. Tribes enforced contracts, they respected property rights. In fact, that's one of the first things John Smith writes when he's in Jamestown. The Indians are very particular with the boundaries of their land. So Indians respected rules and property rights and things like that. And they also had notions of due process. So among the Yurok, for example, they had this concept of crossers. If you went on somebody's land, and you slipped and fell, you could sue them for negligence. Essentially, you would hire 3 people to represent you, 3 or 4, and they were called crossers. The person you were suing would also hire 3 or 4 people, and they would get together and work it out. Whatever they determined, that was the punishment. So very much like a modern day arbitration, not just the raw law of the jungle. And then it's worth noting too that many societies, most tribes lived in small towns, just like most present day Americans live in small towns. But there were some big cities in pre-contact North America. Cahokia is the best known. It's located pretty near present day St. Louis. The population during 1000 to 1300 would have been bigger than London or Paris. And it was a cosmopolitan population too. So DNA evidence shows the people at Cahokia were from as far west as west of the Rocky Mountains, south to the Gulf of Mexico, and north of the Great Lakes. And keep in mind, there's no horses. So people are actively choosing to migrate to Cahokia on foot or by river. So it's a very concerted effort. And about 30% of the population was from that far away. So it's just as diverse culturally as New York or Los Angeles today. And they constructed great mounds too. Cahokia's Monk's Mound is the best known. It's larger than the Egyptian Great Pyramids. So they're a pretty sophisticated society to be able to pull that off. Chaco Canyon is another one. That's located on about an hour northwest of present-day Santa Fe. The Pueblo Indians there built the largest apartment building in the world until the year 1882 at Pueblo Bonita, over 600 rooms. And it had trade networks that spanned over 1,000 miles. It's called Chaco Canyon because cocoa beans have found there from South America. So there's other examples too, Moundville in Alabama, Ascalon, Wisconsin, the Dalles in Oregon. And the point of that is, again, there's a lot more going on in North America than's typically presented in history books. And that is for strategic reasons, which we'll get to shortly. And obviously, there's lots of stuff that occurs when Europeans arrive, but one of the key things for present-day tribal sovereignty is treaties. Treaties are agreements between nations, and all of the European powers enter treaties with tribes. And by choosing to enter treaties with tribes, they recognize the tribes as sovereigns. These treaties were for commercial and military purposes. And the Europeans were eager to ally with tribes and trade with them. And skipping ahead to the American Revolution, among the very first 3 American documents all mention Indian tribes. The Declaration of Independence. We all know all men are created equal and life, liberty, and the pursuit of happiness. But if you keep going, you'll see the colonists are not so happy about the Indian tribe and King George's relationship to them. So the founding fathers described the Indian tribes as the, quote, merciless Indian savages whose known rule of war is the complete destruction of all ages and sexes. And King George exciting them is a reason they have to break away from Great Britain. The Articles of Confederation next mention Indian tribes, and they bifurcate authority over Indian affairs between the state and the federal government. And this led to lots of friction, which will come to play when the Constitution is ratified. Then the Northwest Ordinance. The colonies want to expand farther northwest, and they need laws to do that. One of those enabling it is the Northwest Ordinance. And in the Northwest Ordinance, it specifically states the U.S. government pledges its utmost good faith in dealing with tribes. There's a little caveat in there. You can do just wars, and just war, of course, is in the eye of the beholder. So pretty big loophole. But anyway, the key point is tribes are on the founding fathers' mind as political entities. And when the U.S. Constitution is being ratified, this is clearly at the forefront. So the Federalists want a strong centralized government, and the Anti-Federalists do not. So they're opposing the Constitution's ratification. One of the things the founding fathers used to push the Constitution's ratification is the Indian tribes. So the U.S. has just defeated Britain in the Revolutionary War, and it's the most powerful European nation or group on the continent. So we don't need a strong central government, is what the Anti-Federalists say. The Federalists, however, counter. We still have the Indian tribes here. They're our natural enemies. So we need a strong centralized government so we can rally troops and collect taxes to pay them. So the merciless Indian savage is one of the things that helps get the Constitution ratified. That trope. There's a cool article on it called The Savage Constitution by Greg Oblosky, if anybody's interested. But when the Constitution itself is ratified, Indians are mentioned twice explicitly. Once in the Apportionment Clause, Article 1, Section 2, Indians not taxed. Indians were not taxed because Indians were not citizens of the United States. They're citizens of separate sovereigns. They're in their own tribal governments. So the founding fathers had just fought a war with the rallying cry, taxation without representation. So taxing Indian tribes without representation was a bridge apparently the founding fathers were not willing to cross. Then the Commerce Clause is the most relevant one today. In the Commerce Clause, Article 1, Section 8, Clause 3 states, Congress has the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. There's a with preceding both foreign nations and Indian tribes. This denotes that both foreign nations and Indian tribes exist independently from the US government's immediate control. In fact, the founding fathers would note, the Commerce Clause gives us no more power to regulate the internal operations of tribes than it does the internal operations of France or Spain. They're separate sovereigns. All you can do is regulate the commercial relationships with them through that clause. And the Treaty Clause. Indian tribes are not mentioned explicitly in it. Nevertheless, they were clearly on the founding fathers' mind. They signed treaties prior to the Constitution's ratification, and afterwards, the U.S. continued to sign approximately 400 treaties with Indian tribes. And they went through the same protocols as treaties with foreign powers, such as France or Spain. And again, treaties are agreements between sovereigns. And this brings us up to the Marshall Trilogy. 3 cases decided between 1823 and 1832 that still form the foundations of present-day Indian law. The first is Johnson v. McIntosh. The facts of the case are pretty simple. So McIntosh purchased some land directly from an Indian tribe. Johnson, on the other hand, acquired a grant of land from the federal government for the same exact tract of land. So Johnson proceeded to file a suit to eject McIntosh from the land. And we now know, through subsequent historical work, that there was actually no controversy. The tracts of land did not overlap, so there was nothing to dispute. The case was fabricated to resolve the issue. Do Indian tribes own their land? And this is very important for a couple of reasons. One, if tribes own their land independently, they hold title to it, they can sell it to whoever they want. And this enables them a lot of control and power. Plus, if tribes can sell it to whoever they want, then they can shop around for the best price. If the US is the only entity that can purchase it, it has a monopsony, so it has all the bargaining power. It gets to pick the price, essentially. But the bigger lingering question from a moral perspective is this. If Indians own their land and it's taken from them, that's stealing. That's bad. We're founded as a republic of virtue. We can't be stealing land. That's not a good start. So if Indians own their land, stealing is the result of taking Indian land. So what does the Supreme Court decide? Indian tribes do not own their land. They merely have possessory rights. The US owns the underlying title to all Indian land, and tribes merely have the right of occupancy, the right to remain until the US government decides to extinguish their title by purchase or conquest. And to reach this conclusion, it relies on the doctrine of discovery. The doctrine of discovery is traced back to Papal Bull in the year 1436, when the Pope said Portugal could colonize all of Africa because it was there first, based upon the people being non-Christian. And whenever the European powers came to America, they adopted the principle of discovery. And Justice Marshall notes that no nation abided by the doctrine of discovery more vigorously than Britain, and the US acquired title from Britain. Therefore, the doctrine of discovery governs property rights in America. And to further buttress his conclusion, he emphasized, what are the Indians? They're heathens and fierce savages, so they cannot coexist with the whites. And he specifically says to leave the Indians in control of the land is to leave the land a wilderness. So he's basically justifying the dispossession. And he also claims Indians are non-agricultural, which is important. He knows this is not true. He's educated. He's from Virginia. He's heard of Thanksgiving, you know, when the Pilgrims were fed by the Indians with the crops they had grown. So he knows this is nonsense. But he says it anyway because the leading theory of property rights at the time is John Locke's. And under Lockean theory, if you mingle labor with the earth, you acquire a property right in the land. So if the Indians are farmers, they have property rights under standard European law. So that's why we got to say they're not agricultural, because if they are, property rights, taking land is stealing. So let's just say Indians can't farm. They're hunter-gatherers. And that's Johnson v. McIntosh, and it remains the law to this day. And it's not just background law either. In 2005, the Supreme Court explicitly cited the doctrine of discovery to rule against the United Indian Nations land claim. And also worth noting on that too, last year, the Pope expressly repudiated the doctrine of discovery, which begs the question, if the guy who made up the doctrine of discovery said it's nonsense, why are we still relying on it? But that's a topic for another day. Anyway, the next case that's significant for Indian rights is Cherokee Nation v. Georgia. This case arises because the Cherokee Nation are in Georgia, and they're doing quite well against all odds. They actually have higher per capita incomes in the state of Georgia, and their literacy rate is 3 times the state of Georgia. So the whole idea of getting rid of the tribes is they cannot compete with white people, and now you have the Indians outperforming the whites at their own game. So it's really awkward for the state of Georgia. And plus, gold has recently been discovered in the Cherokee Nation. So Georgia responds to this. Well, before Georgia responds, the Cherokee take further action and ratify a constitution, very much like the U.S. Constitution. And they actually have a Supreme Court before the state of Georgia. So by any manner of civilization, they meet the bar. Georgia, however, insists that they just cannot coexist in civilized society. So they pass a law saying the Cherokee Nation does not exist, and Georgia law governs the Cherokee territory. And they expressly note, Georgia law governs that Cherokee gold mine. And the Cherokee, being a civilized tribe, they don't go to war. Civilized people file lawsuits. So that's what the Cherokee decide to do. And they get a good attorney, William Wirt. He was the former U.S. Attorney General. So Wirt has this issue, though. How do you sue the state of Georgia? To do that, you're going to have to prove jurisdiction. And to get into federal court in 1830, the Cherokee had to qualify as a foreign nation. So Wirt argues the Cherokee Nation qualify as a foreign nation because, first of all, they have treaties with the U.S. and Great Britain. And treaties, again, are agreements between nations. Wirt also notes the Cherokee have their own land base, their own laws, their own government, their own language, their own culture. And under any definition, a group of people that are self-governing is a nation. And to cap it off, he says the Cherokee individuals are not American citizens. What is a nation composed of people who are not American citizens? It's a foreign nation. There's no other option. And Chief Justice Marshall describes this argument as, quote, imposing. Georgia's argument is a little less enthusiastic. It doesn't even show up to the case. So on the one hand, you have an imposing argument, the other, no argument. Who wins? Georgia. What are the Cherokee? They are not a foreign nation. They are a, quote, domestic dependent nation, meaning their relationship to the U.S. resembles that of a ward to his guardian. The court would go on to say the Cherokee are in a state of pupillage. And this is the status Indian tribes continue to occupy to this day. They're not full sovereigns, rather they are domestic dependent nations in this state of guardianship. We now call it the trust relationship because it sounds better, but it essentially means the same thing. You don't have full autonomy. So the Cherokee case gets dismissed for lack of jurisdiction. But a year later, we get a slight twist on the facts. Some missionaries from Vermont had moved into the Cherokee Nation to help them resist removal through peaceful pamphleteering and things like that. Georgia responded by passing a law saying white people cannot enter the Cherokee Nation without a license from the state. The missionaries did not have the license, so Georgia went in and arrested them. It later offered them pardons to try to prevent further hassle over the matter. And all accepted the pardons except 2, Samuel Worcester and Eliza Butler. They instead chose to challenge Georgia's assertion of jurisdiction over them. And they were able to bring the case because they're 2 white guys from Vermont. Now you have federal jurisdiction against the state of Georgia. And with jurisdiction, Justice Marshall walks back some of the things he said in the previous 2 cases. But the most important thing he says for our purposes is the laws of Georgia can have no force inside the Cherokee Nation without the assent of themselves or in conformity with the laws of Congress. Marshall says the whole intercourse between the Cherokee Nation and the federal government is exclusively in the federal government. States have no role to play. So the Cherokee get a W. However, Andrew Jackson is the president. His whole presidential platform was, let's get rid of the Indians. So President Jackson says, John Marshall has made his ruling, now let him enforce it. And of course, this precipitates the Trail of Tears, where approximately 1/3 of the Cherokee tribe dies on their forced march to Oklahoma. And this is worth noting, the Cherokee got removed via a treaty, and numerous other tribes were relocated via treaty too. In treaties, we often think of real estate deals, but they were a lot more than that. So during negotiations, tribal leaders were definitely not in the best position oftentimes, but they still did the best they could to get what they could for their citizens. And they were able to negotiate for annuities, education funding, and healthcare, housing. So whenever people say Indians are getting something as a giveaway or welfare, like, no, they paid for it with the treaty. That was the US's promise. You stop fighting us, we'll give you this in return. That was the deal. So treaties are sovereign bargains. But treaty making ends in 1871. A couple things factor into that. One is after the Civil War, the US is a lot more militarily powerful. The population has grown exponentially while tribal populations are dwindling due to disease and extermination of the buffalo. Plus, you have more modern weapons, and with rail lines, you can transport goods effectively, so the cost of Indian war goes down. Then, just politically, the Senate is in charge of ratifying treaties. The House has no say, but they're responsible for paying for it. Therefore, the House got a bill passed saying no more treaties. So this was a blow to tribal sovereignty, but it is worth keeping in mind the U.S. continued to negotiate agreements with tribes even after 1871. They just were not called treaties. They were still consensual interactions. And states tried to get antsy after the Civil War and claim Indian lands, but the Supreme Court continuously struck those down twice in the 1860s, state attempt to tax. Then in 1879, there's some interesting language I've posted. So Idaho was trying to serve process on someone, and the person fled to a reservation where they were able to then serve him with process. Harkness objected, saying, hey, I was on a reservation. States have no jurisdiction. And the Supreme Court agreed. And the quote, the territory reserved, therefore, was as much beyond the jurisdiction, legislative or judicial, of the government of Idaho as if it had been set apart within the limits of another country or of a foreign states, its lines and bounds of that government. The service was unlawful because it's a separate sovereign. And that was the position of Indian tribes in 1879, completely separate governments, even after being forced from their homelands onto reservations. And before we get onto the other policy area, it's just worth keeping in mind too, civil rights and, looking at past injustices often a la mode, but we often forget about the Indian experience for civil rights. And Chief Standing Bear's struggle is illustrative of this. So in 1868, we get the 14th Amendment that makes all people born in the US American citizens. But there's a caveat in the 14th Amendment that expressly excludes American Indians from citizenship. And so this brings us to Chief Standing Bear. The Ponca were a peaceful tribe and they got relocated to Oklahoma. And on their march, a lot of people died. And when they got there, their conditions were not good either. And many people suffered and died, including Chief Standing Bear's son. Chief Standing Bear's son's dying wish was to be buried on the ancestral homelands. And Chief Standing Bear wanted to honor his son's dying wish. So he left the reservation with a small contingency of people to bury his son back where the son was born. And this was illegal in the 1870s. It was illegal for Indians to leave their reservations without federal permission. So General Crooks goes intercept Chief Standing Bear and he's tried and he's put in jail. So Standing Bear objects to his detention and he files a writ of habeas corpus. The US opposes Chief Standing Bear's habeas corpus on the grounds that you have to be a human being to file a habeas corpus. In other words, the US government's argument was Standing Bear was not a person under the law. Therefore, it didn't have to give him any rights. And Chief Judge Dundee in the Omaha District Court was not known for being a fan of the Indians, and he says some not so nice things in the opinion. And you can see he struggled with the question. But thanks to good old Webster's dictionary, he was able to resolve the question. Webster describes a person as a living soul, a self-conscious being, a moral agent, especially a living human being, a man, woman, or child, an individual of the human race. This is comprehensive enough, it would seem, to include even an Indian. So it's a close call, but Indians are people, and they still have that title. So whoop whoop, we get rare W's, so we should celebrate them. And that is Standing Bear v. Crows. But it's not all high fives because they're still stuck on reservations and things are not so great on reservations. So ex parte Crow Dog. What happens in this case is the Sioux were the most military powerful tribe in the U.S., but they were ultimately forced on the reservation because the buffalo were exterminated, and that was their livelihood. They were the stereotypical, nomadic hunters who lived in teepees. And on the reservation, the situation's politically fraught, to put it mildly. You have the fraction of traditionalists and the people who are more pro-American. And Spotted Tail is the leader of the pro-American faction, and he's in charge of allocating rations. And as what often happens when people get power, he starts taking advantage of his power, and this doesn't go over well with the traditionalist. There's a dispute between Crow Dog and Spotted Tail, and Crow Dog kills Spotted Tail. The matter is resolved pursuant to Sioux custom. The family of the murderer and the victim get together and work out a settlement. This might seem odd to contemporary years, but this makes perfect sense for the Sioux. You're a migratory people. You don't have a jail, so you can't lock him up. And plus, they live by buffalo hunting, which is really dangerous. So if you're upset with somebody, it's really easy to have an accident, and that person's not going to be around much longer. So you need to bring harmony back to the community as peacefully as possible and quickly as possible. And that's what restitution did. So that was the Sioux way. Thus, once Crow Dog's family made restitution, as far as the Sioux were concerned, the matter was resolved. The local white population was not so thrilled with this outcome, so they had the U.S. attorney from Deadwood come in and prosecute Crow Dog. And Crow Dog was sentenced to hang by an all-white jury. Crow Dog must have been a pretty smooth talker because before he was executed, he was able to talk the prison guards into letting him leave the reservation to get his affairs in order. And he was out, and before he was due, there was a big blizzard in South Dakota. And the prison people are like, well, we'll never see Crow Dog again because who's going to ride a couple 100 miles through a blizzard to be hanged? Turns out Crow Dog. So now people are like, Crow Dog can't be such a bad guy. Who's going to ride a couple 100 miles to be hanged? So in response to this, some local attorneys decide to file a petition on Crow Dog's behalf, seeking relief from the U.S. Supreme Court. And the Supreme Court takes Crow Dog's case, and he wins. It says there is no treaty that authorizes the U.S. government to prosecute Indians for reservation crimes on another Indian. Plus, there's no law addressing this issue. But the most relevant point is the quoted text. The court emphasizes the racial and cultural differences. The Supreme Court tries Indians not by their peers, nor the customs of their people, nor the law of their land, but by superiors of a different race, according to the law of a social state of which they have an imperfect conception, which is opposed to the traditions of their history, to the habits of their lives, to the strongest prejudices of their savage nature, one which measures the red man's revenge by the maxims of the white man's moralities. As this would probably be described as racist today, but believe it or not, this is arguably the greatest affirmation of tribal sovereignty to this day. In fact, the Supreme Court majority in McGirt, which ruled in favor of the tribe, cited Crow Dog to support tribal sovereignty. So when a passage that contains superiors of a different race is your best argument, that gives you some kind of idea of how bad Indian law is for tribes today. The last line is also interesting, one which measures the red man's revenge by the maxims of the moralities. So what was the red man's solution to the problem? Let's restore harmony to the community. What's the white man's solution? Hang him. So morality is quite a relative term. But Congress was not very happy with the Supreme Court after ex parte Crow Dog, so it passes the Major Crimes Act. The purpose of the Major Crimes Act is essentially Indians are incompetent to punish major crimes like murder, rape, arson, robbery, for others. So the federal government thinks it needs to punish Indians in order to actually civilize them effectively. So lo and behold, one Indian kills another on a reservation a year later, and the U.S. government moves to prosecute. Kagama doesn't claim he's innocent. Kagama's attorney argues just the federal government has no power to pass the law. The U.S. government counters it does under the Commerce Clause. Remember Article 1, Section 8, commerce with the Indian tribes. So the U.S. government makes one constitutional argument to support its position, and the Supreme Court bats it down. but we think it would be a, quote, very strained construction of the clause. If you make one constitutional argument and you lose, that's usually the end of the case. You made one argument and it lost. But the Supreme Court says this is different because these Indian tribes are the wards of the nation. And the power over these remnants of a race, once powerful, now weak and diminished, is necessary to their protection as well as to safety among those whom they dwell. Thus, the plenary power doctrine was born, which means Congress can pass whatever laws it wants when dealing with Indian tribes, and the Constitution doesn't matter. And this remains the state of federal Indian law. Congress's source of plenary power over Indian tribes has never been identified. Interestingly, Clarence Thomas seems to have a problem with this. He's like, there's no constitutional authority. We said it in 1886. Where'd this power come from? But to this day, Congress can essentially pass whatever law it wants, and Supreme Court's going to uphold it. And with its newly authorized extra constitutional power, Congress passed the General Allotment Act in 1887. And this is the most devastating piece of legislation in Indian history. Whenever you hear about the broken treaties and stuff, the General Allotment Act is at the apex of it all. So the rationale for the General Allotment Act is Indians have treaties that guarantee them reservations for all time, land. And white people want that land. So let's pass a law breaking it up, and we're going to say we're doing it for the Indians' own good. We're going to convert them into private property owning Christian citizens. So the rationale is Indians will get 160 acres. It's placed in trust for 25 years, at which point it can't be taxed or sold. And once each Indian gets his acreage, the remaining lands are deemed, quote, surplus lands, lands Indians don't need, and they're open to white settlers. The idea was as white settlers moved onto the reservations, Indians would absorb the culture of the white people and become Christian farmers and all that good stuff. So I'm sure you will be surprised to learn. Subsequent research has determined that the land Indians got, even though they were supposed to be farmers, was usually not suited for agricultural. White people got the land that was fertile and also had gold on it. So it didn't work out very well for Indians. They lost 90 million acres of treaty guaranteed land. And as you can see, the quote at the bottom is from President Teddy Roosevelt. The General Allotment Act's purpose is to break up the tribal mass, get rid of Indian reservations. And the purpose is we should treat Indians as individuals, quote, like the white man. So it's expressly designed to terminate tribal culture.
Adam, if it's okay, can I share a little information about how that impacted my tribe, the Iowa tribe?
Oh, certainly.
Okay, well, after the Allotment Act and all of our members got our acreage, this idea of, what's this land deed, what is this piece of paper that we were given, this land deed, didn't really make much sense. It was such a colonized viewpoint of land ownership and documentation for us that we had struggles with producing enough food to actually feed our people at times. And a local general store so generously offered to provide us food. And if we didn't have money, he would go ahead and take our land deeds as collateral. And as you can imagine, without having many economic engines at that point in time, many of those land deeds that were put up for collateral ended up going to the general store owner. So even the lands that our tribal members were given went to a general store owner because it was a choice between starving and dying or giving this piece of paper to a general store owner to live. And we lost a large portion of our land. And we're still trying to get our land base back as a result of the Allotment Act. So I just wanted to, that is the real world implications of an Allotment Act that happened in 1887, is that we are still struggling. We still have a lot of public housing in which people live in. We don't have that many private tracts of land unless they're owned by private non-native citizens.
Yeah, thank you for that, Misty. Yeah, unfortunately, that's a pretty common story in Indian country, similar things. Things got a little bit better in 1934, I guess being.
I will say just really quickly, we were able to, buy that general store back though. So now our tribe owns that general store. It took us a while, but we now even own the general store in which that man took all of our land deeds. So there's at least a silver lining to that story. I don't want to just leave with something negative. Sorry, Adam, go ahead.
Oh, no worries. Yeah, put that in the movie about the pawpaws. Um, but yeah, so the Allotment Act lasts until 1934. Tribes keep losing land through allotment until 1934. At that point, basically all the fertile land has already been taken from tribes, so the desire for Indian lands has decreased, and that enables the Indian Reorganization Act to get passed with the express person of preserving tribal land bases. So it locks them in trust, which is good because it prevents alienation, but it comes with other problems like you can't access capital and it's really difficult to use. And that contributes to some of the housing problems that Misty mentioned. The IRA formalized tribal governing structures, and it did this in a very Western way. It basically gave them a city council type governance structure in many tribes. And there's provisions to promote economic development, but there's lots of questionable things that occurred during the IRA. Like tribes were theoretically given the option to vote on it, but many of the elections were held under questionable circumstances. But most tribes ended up getting IRA constitutions. And even though it was designed to, quote, empower tribes, there's lots of paternalism baked into it. For example, Felix Cohen, who wrote the IRA and many tribal constitutions, said the IRA gives the Secretary of the Interior the power to set Indian bedtimes. So lots of paternalism baked in. And you can see that quote from Harold Ickes, who was Secretary of the Interior when the IRA was passed. It was done for paternalistic reasons. The whites can take care of themselves, but the Indians need someone to protect them from exploitation. So that was the background thought of the IRA. Then the IRA was still a relatively high point because soon after World War II, the federal government turns to terminating tribes. And it's basically exactly what it sounds like. With the stroke of a pen, the president terminated some tribes. Administratively, some tribes were terminating. Congress passed some law saying tribes, you no longer possess sovereignty. And when that happened, reservations were liquidated slowly, and non-Indian interests were able to seize Indian assets through termination. Public Law 280 is the most infamous of the termination legislation. What it did was withdraw federal criminal jurisdiction over Indian country and allow states to exercise civil and criminal jurisdiction over Indian country. A few tribes, like Misty's and other Kansas tribes, had special laws before that, which were a precursor to PL 280. So what the purpose was actually was to save the feds money. So that was one of the big emphases. If the feds aren't responsible, now we can just pass the costs off to the state. But PL 280 expressly says states cannot tax tribal lands. So states who often have we'll just call it tense relationships with tribes, don't have much of incentive to police lands they cannot tax. So what studies typically show is that tribes that are subject to state jurisdiction experience higher crime rates because the feds can't act. The states don't want to, and tribes have no jurisdiction, which we'll get to in a little bit. So it's a really bad criminal jurisdiction setup. But my favorite piece of legislation from the termination era is the Indian Relocation Act of 1956. So Congress said Indians are poor. How do we solve Indian poverty? Buy them a bus ticket. And that is the Indian Relocation Act. As you can imagine, it did not work out very well for tribes. And it's worth noting on too, a fun fact. So the same guy who was in charge of rounding up the Japanese and putting them in internment camps is the same guy who was in charge of the Indian Relocation Act. So yeah, very pleasant fellow.
The implications of the Indian Relocation Act on today is that I think many of you have worked with like urban Indian centers or urban Indian kind of healthcare facilities. And oftentimes those are located in hubs where a lot of Native people were relocated to. I was actually just with one of my tribal elders this morning, and she and her family were in California. And there were a lot of members of my tribe that ended up in California because of the Indian Relocation Act. So that's why you might work with urban Indian centers or urban Indian healthcare facilities, and those are oftentimes in the hubs where many natives ended up going to as a result of being bussed away from their reservation.
Yeah, and as Misty noted, yeah, it was usually really big cities, which could have been like just a huge culture shock for the tribe. So there's not really much TV on the res in 1956. So basically, you're going from maybe speaking exclusively Navajo to Chicago, completely different climate. It's a huge culture shock. It led to lots of problems for the families that were relocated. And unsurprisingly, the support they were promised when they were relocated usually did not materialize. So lots of social issues have resulted from that. Then a couple other legislation that's relevant. So we get the Indian Civil Rights Act in 1968. So again, tribes are not bound by the U.S. Constitution. It's a controversial act because it was imposed on tribes, the Indian Civil Rights Act. They did not seek tribal consensus. The federal government just imposed it on tribes. And worth noting, as far as the text itself, it basically replicates the Bill of Rights, but there is no establishment clause because some tribes have theocratic governments historically. And if there was an establishment clause, that would be unconstitutional under the Indian Civil Rights Act. So tribes have the power to establish religious governments. And there is no Second Amendment in the Indian Civil Rights Act either, which one might wonder, where was the NRA on that one? But yeah, Indians do not have the right to bear arms to this day. But policy shifts drastically in 1970 when Richard Nixon comes into office. So by leaps and bounds, Nixon is the best president tribes have ever had, which seems odd, but there's a reason for it. So President Nixon's lifelong goal was to play defensive tackle, which is a perfectly noble goal, but he's not exactly built for it. He was like 5'8", $160. So he didn't get very many opportunities until he went to Whittier College. Coach Wallace Newman let him try out for defensive tackle. He didn't make the team, but he got a chance. And Wallace Newman, the guy who gave him the chance, was an Indian. So from that day forward, President Nixon, well, then just Richard Nixon, pledged to do all he could to help the Indians. And he made good on his word. In Nixon's autobiography, he said Wallace Newman was the most influential person on his life outside of his father. And he actually tried to put Wallace Newman in charge of Indian affairs. But that aside, so based upon Nixon's inspiration, when he comes into office, he gives a standalone speech to Congress expressly addressing Indian affairs. He says tribal termination is wrong, both morally and from a policy perspective. And he advocates that Congress adopt a policy of tribal self-determination. He says we try to promote local government in the U.S., and tribes should have that same privilege. And Nixon is the first president to restore lands to an Indian tribe as well. Nixon pushed for full tribal self-governance, but tribes were a little suspicious given the recent termination era. They thought it was a backdoor thing, and before Nixon could do much, of course, he gets into a bit of trouble. So Nixon's full dream never came true on that front, but it did blossom into the Indian Self-Determination and Education Assistance Act of 1975. Basically, what it did was enable tribes to take over federal programs. So let's say you have a forest on your res and the feds are going manage the woods. Now the tribes can take the money the feds would have previously spent on the program and operate the program themselves. So it's designed to foster local self-governance. And what studies have consistently shown is that tribes that have taken on more self-governance functions tend to perform better economically. And it makes sense, of course, because they're actually living right there. So they have a greater incentive to manage the resources. But even though Congress and the president are about tribal self-determination, the Supreme Court's not such a fan. In fact, it's gotten much worse, as you can see by the ominous dark screen, which looked aggressive when I just turned it. Anyway, so the big case here is Oliphant v. Suquamish tribe, decided in 1978. So the Suquamish tribe is located right outside of Seattle and on the Port Madison Indian Reservation, and it's hosting its annual Chief Seattle Day celebration. It knows there's going to be lots of people there, so it calls the local police and it requests law enforcement support. They are willing to provide one cop for an 8-hour shift over the 3-day festival. They request policing support from the feds. The feds decline. So the festival goes on, and Mark David Oliphant, who lives on the reservation, decides to attend, and he gets drunk and disorderly, so the cops are called. The only cops around are the tribal police because nobody else wants to help. And when the tribal police show up, Oliphant proceeds to punch the cop. As you might imagine, it's illegal to punch cops under the Squamish Code, so they move to prosecute him. Oliphant doesn't argue he's innocent. He doesn't claim anything. His only argument is he's not an Indian. Therefore, the tribe should not be able to prosecute him. The federal district court said that's a really dumb argument. The Ninth Circuit Court of Appeals says this is a really dumb argument. The Ninth Circuit Court of Appeals emphasized the guiding star of federal Indian policy is tribes have all the powers they have not expressly relinquished. At no point in time have the tribes ever relinquished the power to prosecute non-Indians. And of course, Oliphant was not able to point to anything supporting that theory. Furthermore, the Ninth Circuit noted Congress has just adopted this policy of tribal self-determination. It's trying to foster tribal self-governance. And being able to arrest bad guys is very essential to be able to self-govern. However, the Supreme Court said no. Tribes do not have criminal jurisdiction over non-Indians. And it's a really remarkable opinion. And I'll try not to rant too much, but I do get excited because it's just so great. But anyway, so at the beginning of the opinion, the Supreme Court states the effort of Indian tribal courts to exercise criminal jurisdictions over non-Indians is a relatively new phenomenon. The problem with that statement is it's just simply not true. So let's just think. You have John Smith get out the vote in Virginia. He goes stab an Indian. Oh, you're a white guy. Just stab away. We can't do anything. That just never happened. You know, it's just not how it worked, obviously. And if you doubt that, there's multiple treaties between the U.S. and Indian tribes that expressly state tribes can prosecute non-Indian criminals. There's also federal reports from the 1830s saying tribes can prosecute the white people within their borders. And if that's not enough, the US government was actually turning over white fugitives to the Indian tribes to be hanged in the mid-1800s. So depending on what your perspective relatively new is, that doesn't sound like prosecuting non-Indians is a, quote, relatively new phenomenon in the mid-1800s and before that. So just a very odd claim. And of course, he cites multiple cases that are, to put it mildly, quite antiquated. The Marshall Trilogy, which we talked about, Crow Dog and Kagama, which we talked about. Did I forget to do this? Yes, okay. I forgot to eliminate the slide. Yeah, so we'll just pretend like that didn't happen. But anyway, so we have the Marshall Trilogy and Crow Dog Kagama, which we talked about, but US v. Rogers is another one from the mid-1800s that's very relevant and was quoted by Oliphant. So US v. Rogers is a case that involves two white guys who became citizens of the Cherokee Nation. So going back to the political status I brought up earlier, tribes are governments. It's not a racial classification. So Sam Houston, for example, the famous Texan white guy, was a Cherokee. He moved in, he learned the language. So as far as the Cherokee were concerned, he's Cherokee. They didn't ask for blood quantum or anything like that. In fact, the Cherokee chief at this point in time was 1/8 Cherokee by blood, John Ross, 7/8 Scots-Irish. So the Cherokee don't have any problem with, quote, non-Indians being Cherokee. But one of those people, Rogers, is a white guy who's Cherokee. He kills another assimilated Cherokee, and the feds move to prosecute on the basis that they're white. It has jurisdiction over them. And Rogers appeals, saying the federal government does not have jurisdiction over Indians on a reservation. So the only issue in the case is Rogers an Indian, this white guy who's a Cherokee citizen? And the Supreme Court says no. And it says from the very moment the government came into existence, the federal government has exercised its power over the, quote, unfortunate race. That is, Indians are an unfortunate race. The government exercises jurisdiction over in the spirit of humanity and is trying to improve their minds and increase their comforts, save them from their own vices. So essentially, white people cannot be Indians because Indian is a racial classification. The court would later go on to say that if we let this happen, all the, quote, mischievous white people will become Indians. They're the only ones that consort with Indians. And this opinion is notable too, because it's written by Justice Roger Taney, who's infamous for writing Dred Scott, which of course he says black people have no rights, which white people are bound to respect. So the same guy who wrote Dred Scott is the guy who determines who an Indian is until the 21st century. The Rogers test is still used in federal court to determine Indian status. So that's what Oliphant relied on. And there's only one case in the whole history of the US that supported the Supreme Court's position. And that was a lower court case decided 100 years ago by Judge Isaac Parker. If anybody's seen the Bass Reeves TV show, Judge Parker's in there quite a bit. So Judge Parker says that tribes cannot prosecute non-Indians. This is not binding to the holding of the case, so it's not even the law. It's purely dicta. So it's odd that you would cite century-old dicta. If you're a law student and you do this, you get a bad grade. But what makes this opinion even more interesting is he passed footnote 10. And you can look this up on your own if you don't believe me, because it's pretty silly what I'm going to show you. So in the footnote, Chief Justice Rehnquist writes, Judge Parker's views of the law were not always upheld by this court. Translation, Judge Parker was not a good judge. In fact, he's famous for being a bad judge. His courtroom was known as the Court of the Damned because he hanged so many innocent people. He was overturned 2/3 of the time on appeal, whereas the standard appeal affirmation rate is 90%. So basically, if Judge Parker said something, the odds are it was wrong legally. So it's an odd thing to do, cite a guy who you're admitting is not a good judge. It's like the legal equivalent of cheating off an F student. It's just bizarre. But that's what the Supreme Court decided to do. The court also says Judge Parker's views as to the ultimate destiny of the Indian people are not in accord with current thinking on the subject. Translation, most people in the present day US would consider Judge Parker a racist. He was one of those people who was a champion of boarding schools. Kill the Indian, save the man. That was Judge Parker's views. Indians need to be civilized. So he's a bad judge and he's racist. Why would we bother citing him? Well, the Supreme Court says the Indians liked him. And we know this because one of his biographers, describing Judge Parker's funeral, states that after his grave was filled, the principal chief of the Choctaws, Pleasant Porter, came forward and placed a wreath of wildflowers on his grave. That's a pretty odd legal authority. Somebody put flowers on his grave, so that's the law. It begs multiple questions too. Why did Pleasant Porter put flowers on his grave? It could have been, I'm remorseful that he's dead. It could have been a political gesture. Things were dicey for Indians in Oklahoma circa 1900. So it could have been a political game. It could have been good riddance. We don't know. Nobody asked Pleasant Porter. It also raises the question, one Indian put flowers on the grave. What if two Indians go poo-poo on his grave? Now we've got two Indians going, defecate versus one placing flowers. How do we weigh these things? It's not entirely clear how this works out. But most relevant, the principal chief of the Choctaws, Pleasant Porter. Pleasant Porter was not the chief of the Choctaws. He was the Creek chief. So if we can't even get the tribe right, how much veracity can we give this statement? So it's a really legally bizarre opinion that doesn't make much sense and has been widely condemned in academic scholarship. Nevertheless, the Supreme Court continues to abide by it, and it's had drastic consequences for public safety in Indian country. The foremost being tribes can prosecute Indians, but tribes cannot exercise criminal jurisdiction over non-Indians. So if you're a non-Indian and you go on a reservation and you stab somebody, the tribe can't arrest you and put you in jail. That's the general rule. That was only modified in 2013 with the Violence Against Women Act. That allowed tribes to put non-Indians in jail for dating violence, domestic violence, and protective order violations, but only if the tribe adopted strict procedural safeguards. In fact, the procedural safeguards are more stringent than the state or federal government must provide to defendants. And VAWA has been modified, and most recently in 2022, now tribes can exercise jurisdiction of a total of 9 crimes, mostly relating to domestic violence. And it's extended to civil jurisdiction too. Now it's not even clear whether tribes can hold non-Indians civilly liable for the torts and breach of contracts they commit. The Supreme Court in 2016 split 4-4 over whether Mississippi Choctaw Tribal Court could exercise jurisdiction over Dollar General's negligent hiring by permitting a pedophile to molest tribal youth. The Supreme Court split 4-4 on that. So it's not entirely clear, but it's very relevant for public safety. And even if tribes can put somebody in jail, the maximum sentence is 1 year, unless they adopt the Tribal Law and Order Act, which about 30 tribes have done. The maximum jail sentence per offense under the Tribal Law and Order Act is 3 years. All this means is that tribes depend on state and federal law enforcement, and it's not so straightforward. So states have jurisdiction over crimes that involve only non-Indians. The feds have jurisdiction over crimes that involve both an Indian and a non-Indian. Then some states have jurisdiction over all crimes on reservations, it's not entirely clear how it works. And to exacerbate things, nobody knows who an Indian is. Different federal courts use different tests. So, for example, you can be an Indian in the Eighth Circuit Court of Appeals, but you wouldn't be an Indian in the Ninth Circuit Court of Appeals. And it can take months to figure this out. So, if you're a non-Indian law enforcement officer, you probably have better things to do than drive 100 miles to the reservation where your Wi-Fi is not going to work. You're not going to have paved roads to get to a crime scene. And it's just very complicated because even if you get there, it's not clear you can arrest the people anyway. So it's just a very inefficient system. And that contributes to many of the high crime systems we see. So in 2010, Congress reported violence against American Indian and Alaska Native women has reached epidemic levels. In 2015, a federal report determined that 40% of Indian women were victims of violence. 4 in 5 Indian men are going to be victims of violence during their lifetime. And children have the highest rate of violent victimization of any race of children. In fact, Indian children suffer from PTSD at rates the same as American combat veterans due to the high rates of violence on reservation. And it's worth noting, too, these estimates are way underestimates according to most experts because Indians just typically don't bother reporting crimes due to the bad response rates. And another particular thing which I didn't note is unlike most other races, the vast majority of violent crimes committed against Indians are committed by non-Indians because non-Indians know they can go on the reservation. And if you stab an Indian, it's going to take years just to figure out whether or not the police can arrest you. So if you're a bad guy and you want to do things, reservations are a good place, thanks to Oliphant. And on that chipper note,
I'll also say I'm going to this before we get too chipper. Trigger warning for some. Nationally we hear about rates of rape for women being 1 in 4. Native-led researchers are actually finding that when a Native woman asks another Native woman through Native-led research, it might actually be closer to 80%. 80% of Native women. So that's what this, when he says likely underestimated, very likely underestimated dramatically. Yes, Christine, it is horrifying. So yeah, understanding the legal landscape for some of these things are really important. Adam, I'll let you close if you have any other final comments before we shift to questions though.
Oh no, that was it. No, I thank you for the opportunity and yeah, around for questions.
Okay, great. I want to touch on and Adam, I gave you a heads up. Also, wanting to talk a little bit about the regulatory policy environment. I know some folks work in childcare licensing and kind of childcare regulatory environments. And I can talk a little bit about kind of also SNAP. I know a lot of folks work in SNAP and SNAP access. So I'll talk a little bit about the impact of the SNAP regulatory environment and tribal authority. And currently, tribes have really no authority to change SNAP rules or regs at all. The federal government does give some authority and delegate some authority to states and funding as well. And currently tribes don't get any of that. They don't get any authority. So it is up to the state agencies to run the SNAP programs in ways that they deem fit. I will say I'm a part of the Native Farm Bill Coalition, and we are actively working on advocating for what's called 638 authority, which is our self-determination authority. So we can run our own SNAP feeding programs on the reservation. So that's an example of working with a state agency, while they do have to serve tribal people, working on a state policy without consulting Native people that may be impacted might be missing the mark. And the other thing I want to say is that it's complicated. Like Medicaid state plans, that's a state level issue that yes, they're supposed to consult with tribes, but how meaningful consultation happens is just like, hey, we're doing it. Let us know what you think. Bye. Okay, we check that box. We're done. But Adam, and childcare licensing as well. I know we touched base on this, Adam. The states that do licensing, that is something that they have the authority to do. Tribes also have the authority to pass their own codes for childcare licensing and rules and regs that way. Not every tribe does that. Many tribes don't. It's based upon capacity. Like, as you can imagine, it takes a lot of money and staff to actually have your own tribal codes, to run your own licensing programs. So some tribes don't do it simply because it's a capacity issue. So like a childcare regulatory environment can be very different from tribe to tribe and state to state as well, based upon if the tribe has passed their own rules and regs or codes related to that. Adam, did you have anything else to add?
I guess the only thing I would tack on to what you said is even if a tribe does pass a licensing requirement, the state doesn't have to recognize it, and the tribe doesn't have to recognize the states either. So that can cause conflict. So there's the full faith and credit clause that obligates one state to recognize the other state, but tribes again are not bound by that provision. So that can create issues as far as which one to honor.
Mm-hmm.
It's like Ben Schmaus has a question. He has his hand raised.
Yeah, thanks for the presentation. Really appreciate it. In that same vein, in the early care space, for early childhood education or prenatal 3 type of stuff, we oftentimes abiding by and getting, what's the right word there? Getting licensed and also recognized is a requirement for federal funding. And can you speak a little bit to any of the situations that the tribes have been able to create their own regulations and have those regulations recognized as meeting federal standards so they can access federal funds to provide quality childcare, but quality childcare in a way that they feel like honors their culture? Because it's one of the things we've worked on with the Suquamish tribe a little bit in our Voices work.
Yeah, I'm not very familiar with the child care space. I know under the Indian Child Welfare Act, states are obligated to recognize tribal court judgments, and there's certain provisions like that. But unfortunately, that's Misty. Do you know more about that? Or
I would say I can't speak for all of the tribes, but I know based upon my experience, the couple tribes that I've worked with, we have decided that it is in our own financial best interests to defer to state licensing, because we know that any sort of early childhood or pre-K, all of those centers, there's razor thin margins to begin with. So if we are going to exercise our own authority to have our own licensing, and the state may not recognize it or the feds may not recognize it, we're doomed for failure. So I would say, just generally speaking, a lot of the smaller tribes will struggle with that because the margins are already so thin. To have to put our own codes in place that may end up undermining our financial sustainability of childcare, it ends up just being easier to defer to the state regulations, which is unfortunate because then we don't get to be in charge of our own destiny. We are truly at the hands of the state regulatory agency to inspect us. And I'll be totally honest. And sometimes I've actually called state agencies to say, hey, I need your help on this sort of inspected facility. And they say, oh no, you're a reservation. We don't do that. And I say, no, but in this case you do. And they say, no, we don't. So even if we don't have our own codes, calling a state agency for help, they're so hands off. It makes it really, really challenging. So that's actually the lived experience is oftentimes our hands are so tied and it's so hard. We just defer to state, and it's a battle that is impossible for us to fight unless you spend a few years fighting it and and trying to get it done. And that is exactly what I'm doing with my tribe right now, is trying to get childcare capacity strengthened and enhanced. And it's not easy. It's not easy.
Thank you for sharing.
I guess the only thing I'd add on the capacity point is one one of the things tribes really struggle with is just funding in general. And part of that is because the tax rules in federal Indian law are so tricky. So states cannot tax tribal lands, but they can tax just about anything else. So like if the tribe sells, I don't know, let's just say some beef on its reservation, the state gets to tax that. And the state usually doesn't spend those dollars on the reservation. So that prevents tribes from having a tax base because, of course, if a tribe wants to impose its tax and the state's also taxing, then nobody's going to go shop on the res where you tax twice instead of tax once off the res. So this puts tribes at a huge disadvantage from an economic development and just capacity building standpoint.
I see your question, Mark. Is there a resource or short answer to understand legal or other formal relationships the sovereign tribes have amongst themselves, independent of the U.S. government? Adam, do you want to take a quick stab at that, or do you have anything?
Well, I have a book coming out. I don't know what's going to be published, but yeah, it should be by the end of this year, so we can get you a copy, Mark, and I'll sign it for you. Yeah, Reservation Capitalism has some stuff on that by Robert Miller. That's a short read. It's pretty well known. Why can't I think of it? Frank Palmersheim has a few books. I can't think of course I'm going blank, but Indian Law in a Nutshell, I guess, is a good one that gives you just a background on Indian law. Of course, it deals with more of the federal things than you're probably asking for, but it's pretty comprehensive and relatively short. So that's probably the best primer for just a comprehensive examination of the law.
I'll also share, and I've shared this with a number of folks, tribes are not necessarily governed by the state sunshine laws either. So like if you're trying to look for tribal codes or tribal laws, you might experience challenges in finding those as an outsider. My tribe, for example, does not post our codes anywhere. In fact, we keep most of our stuff in a members only portion of our website. So that's how we have transparency among our members, but anyone who is not a citizen of our tribe or a member of our tribe, you won't have access to that. And the only way that you can get access to that is to have a really strong relationship with the governing body and the staff in which they approve sharing those documents. And some tribes, like my own, do keep those to ourselves. Other tribes do actually have all of their codes online. I think of a neighboring tribe, Prairie Band Potawatomi Nation. I've actually gone on and pulled off some of their codes. I believe Ho-Chunk, Winnebago has some of their codes online. There are a number of tribes that actually do have their codes and their laws online as well, but it is not a requirement by any means. They don't have to do that unless they choose to do that, or they pass their own laws stating that they will have that in a publicly accessible way for everyone. And are there any other questions that folks have either in the chat box or raising your hand and coming off mute?
There's nothing else in the chat right now, Misty.
Okay, hearing none, I will say I would like to thank everyone for taking over an hour out of their day to come and spend this Friday with us. And if there's anything that you take away from this presentation, I think, as you can imagine, based upon Adam's comments and all of the knowledge that he shared with us, it can be hard for non-Native folks to work on policy in Indian country and not get a really hesitant reaction. And I think Adam shared the history of why non-Native folks working on policy and law in Indian country has come back to bite many tribes. So really building those strong, trustworthy relationships with your Native and Indigenous partners. Start with that. Start with that relationship without an agenda. The way I describe things is if you build the relationship first, the transactions, the contracts, the shared agendas, it will happen naturally later, but you have to have that relationship, that strong foundational relationship before anything can move. So that's the one thing that I would like for you all to take away today. Adam, did you have any one main takeaway that you would like to share with the group? You don't have to.
No, well, just mostly thanks for the opportunity. And remember that tribes are governments, they're just separate sovereigns and, they're not social clubs.
And I will just say, if you guys want to get down to your reactions and give Adam a round of applause in your reactions too. Thank you so much, Adam, for sharing, and thank you all for taking the time out of your day to listen. And I will stand prepared to work with Nada and the Voices team on any additional follow-up that you all may find helpful. So thank you all. Hope you
All
have
right,
a nice
thank you.
day.
Thank you, Adam. Thanks, everyone.